113299, State of Kansas v. Sandoval.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant, Ernest Sandoval. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly state the facts, back in 2010, Mr. Sandoval pled no contest to 1 count of aggravated indecent solicitation of a child. At sentencing, the district court imposed a sentence of 34 months in prison, followed by 24 months of post-release supervision, subject to a term of probation. The post-release aspect of that sentence was illegal, however, it went unnoticed for a time. In 2012, the district court revoked Mr. Sandoval's probation and imposed his underlying sentence. Later still, in 2014, the state moved the district court to correct the post-release aspect of Mr. Sandoval's sentence from a term of 24 months to a term of lifetime. The district court granted that motion. Mr. Sandoval appealed. On appeal, the Court of Appeals affirmed. We petitioned to this court, and this court granted review. And that is how we got to where we are today. So moving to the legal issues on appeal, I guess I'd like to start off by explaining what I think is problematic about this case, which I don't think is really addressed by the Court of Appeals' opinion. And that is, at a probation revocation hearing, a district court can give any sentence which is equal to or less than the sentence imposed at initial sentencing. So had Mr. Sandoval been sentenced correctly at initial sentencing and received a punishment of lifetime post-release, at a probation revocation hearing, the district court would have had the opportunity to consider whether some sentence less than lifetime was appropriate in this particular case.
And let's just stop right there for a second, if we may.
Just to set something up, is the original sentence that was imposed with the 24 months of post-release supervision an illegal sentence?
Yes,
at the time it was imposed? Okay.
Yes,
that's my question. I just want to set that up.
Okay, and I want to focus on the word opportunity, because it's clear that there was an opportunity to change the post-release period at that point. But isn't it also clear from the record that that's not what happened? The judge left that 24 months in place. There's nothing in the record to support that the judge had any intention to change that to some lesser period.
If I'm understanding correctly, Your Honor, yes. The district court, the sentence was at the time of the PV 24 months, and that's what the court very explicitly...
Just left it in place. Yeah, very explicitly, exactly. There was an explicit intention to leave it as is.
That's correct.
Okay. So how do we even get to the statutory provision here? I mean, in order to hold your way on the first issue, don't we have to discount whatever the judge's intention was and say by operation of law, the mere fact that there was an opportunity statutorily to do something lesser means that that's in fact what happened?
Yes, I think that's right, Your Honor, and I think that's what this court's case law indicates is the appropriate course of action. I think the McKnight and Abasolo cases are very clear that a court's legal mistake or factual mistake about a defendant's underlying sentence is immaterial to what a defendant's sentence actually is following a probation revocation.
Which is why they could correct the illegal sentence later. I mean, I think that the nature of the legal error on McKnight was different, wasn't it?
Well, slightly, Your Honor. Yes, a little bit.
Yeah, entirely, wasn't it? In McKnight, wasn't there a change, an intentional change that turned out to be legally unsupported?
Yes.
That didn't happen here, did it? That's a pretty critical distinction from McKnight, is it not?
Well, that is a distinction. And I would also note that Abasolo is also similar to what happened in this case. In that particular case, you have a factual misunderstanding about what a defendant's underlying sentence actually was. Whether it was, I believe, I'm not going to get the terms right, but whether it was a 36-month term of prison or a 50-some month term of prison. The district court mistakenly believed that it was a 30-some month of prison underlying probation. That mistake of fact didn't change the fact that the district court's very explicit probation revocation sentence was not ambiguous, and therefore it was what a defendant's actual sentence was. I think that's also analogous to this case.
What you're saying is that 24-month post-release was not statutorily authorized at original sentencing.
Yes, sir.
But it was authorized at the probation revocation hearing.
Yes, Your Honor.
And what I hear you saying is it doesn't matter if the judge intended to have, say, the max post-release or whatever, if the pronouncement was what it was and it was authorized, then that's a sentence.
That's correct, Your Honor.
And how do we analogize the pronouncement at probation revocation with the pronouncement at sentencing? Obviously, we got all kinds of cases that says whatever's said at sentencing is what goes. How do we get to the place that that also works with the probation revocation? Do we have any case law that says that the pronouncement of disposition is the same as the pronouncement of original sentence?
I think that's exactly what Abasolo and McKnight say, is that a probation sentence is what a district court says it is. And really the only thing that matters is what the district court says, so long as it is a statutorily authorized probation revocation disposition.
And what was authorized here included leaving the post-release in place, which is what the judge said.
That's correct.
Okay.
We
I have
have a
another
whole-
question. Oops, excuse me.
We have a whole slew of cases where we have reversed and remanded when a judge has imposed a parole when it should have been post-release, or vice versa, when they've imposed post-release and it should have been parole. Are those cases just wrong?
Well, I don't think...
Why is it that we're not following the thing that was said at the sentencing hearing? We're allowing a modification of that sentence. We're saying that legally it has to be modified.
I don't think it has to be modified. If I'm understanding correctly, Your Honor, I think the line of cases dealing with lifetime parole and lifetime post-release, those are just changing what a defendant's sentence at the time of sentencing is. A defendant has an illegal sentence at the time of sentencing, therefore this court is correcting that illegal sentence. The difference in this case between those cases is that once we get down to the probation revocation hearing, we no longer have an illegal sentence because the district court had authority to impose a term of 24 months of post-release supervision.
But at least in this case, it doesn't appear that the court recognized that he had that authority. Rather, he was just intending to reimpose what was the original sentence. And so why under those circumstances can't that sentence be changed, much like we do with the post-release situation?
Because it becomes final after it's a probation revocation sentence. I guess to answer, I view these two sentences as entirely distinct things. There's the sentence which is given at sentencing, underlying a term of probation, and then when probation is violated, we have an entirely new sentence, which is legal. And because it's legal, it just cannot be modified.
So to get to where you want to, we have to recognize this as a separate sentence, in your view.
I think that's correct, Your Honor, and I think that's consistent with this court's precedent and case law.
Here's my other question, counsel. There's an introductory phrase in the statute, in the probation revocation statute, about unless otherwise provided. And if in fact the statute, if in fact a 24-month was illegal, mean, does that language, that introductory language, have any bearing on your argument?
I don't believe so, Your Honor, and I guess I don't have that statutory provision right in front of me, but I'm not sure what the
Well,
unless.
you're arguing the mere existence of the ability to sentence to a lesser term in the probation revocation statute. That the mere existence of that language means that that's in fact what happened. It implicitly happened, whether the judge meant it to happen or not. That's what happened. It's a new sentence, etc. But that unless otherwise provided introductory language in the statute might indicate that if in fact that's what the judge wanted to do and that would have been illegal, he couldn't do it. You understand what I'm saying?
I believe I do. And
Okay.
I don't think that's what it's referring to. I think that language in the statute is just saying if there's a more specific statutory provision that's on point, which I don't think there is in this case, that
Couldn't
would
you
control.
characterize a statute that says that an offender of this, on this particular crime must have lifetime post-release is more specific than the general probation revocation statute?
Well, I don't think it is, Your Honor. I think that McKnight would support that. You have the similar problem there of that there was a statute that said post-release was required, and McKnight recognized that the any lesser sentence provision in the probation revocation basically trumped that.
And it says any lesser sentence. It doesn't say any lesser legal sentence.
That's correct.
And we've said that, say, the grid box has a minimum of 22 months. We've allowed 12-month sentence on a probation revocation, which would have been illegal if originally imposed. Haven't we?
That's correct, Your Honor. And just very briefly, I did want to touch a little bit on issue 2.
Before you go on to that, can I just ask a question about that? We do have statutes that give us a mechanism for departure, a dispositional or a durational departure on the term of imprisonment. But there are no statutes that give that kind of a green light to departing on the post-release period, is there?
No,
And does
Your Honor.
that matter? That there's just a silence so that there is no affirmative authority given to a judge under any circumstances, arguably, to depart from that length of post-release supervision?
I don't think that matters, and I think that this court has actually come across that exact same issue in McKnight, because when you're talking about term of months post-release, judge doesn't have any discretion to give no post-release in a 36-month post-release case, or 24 months post-release in what's supposed to be a 36-month post-release case. Post-release just is what it is. There's no other option. And in McKnight, this court held, nonetheless, if a judge says no post-release at a probation revocation hearing, then there is no post-release. So I think that's very similar to the concern raised by your question, Your Honor. And then just very briefly on the last issue, if this court were not to agree with us on issue 1, for sort of the reasons that I was expressing in my introduction, I think that there would at least have to be a remand for a new dispositional hearing in this case.
Are they completely mutually exclusive? You argue that he didn't have an opportunity to argue for a reduction in his post-release time. But that's not literally true, is that he had an opportunity to argue for a reduction from the 24 months, and that was evidently rejected because the judge said, no, we're going to stick with the 24 months. What he didn't have an opportunity to argue was that the judge should reduce it from lifetime to somewhere between lifetime and 24. Isn't that right?
That's right, Your Honor.
Okay, so no matter how we come out, I mean, I'm just struggling with this mutually exclusive idea of the two remedies.
Well, I think that they may be logically inconsistent, and that's why, issue number 1 in our brief is the course of action we believe that this court should take.
And that remedy, you say, is just to give him 24 months, not to send it back for reconsideration of what it would be between lifetime and 24. Don't you have to accept the risk of that as well? I mean, isn't that possibly what should have happened here? That the judge should have had lifetime down to 0 to consider at the at the disposition?
Well, that's what should have happened procedurally. Yes, I mean, it's not what actually
So
happened.
isn't that in fact something that might be necessary even if we think you might be right on issue 1?
Well, I don't...
I mean, I'm just questioning the character of the remedy you're seeking on issue 1.
Well, Your Honor, I mean, as a matter of public policy, I could see why maybe this court would be inclined to go down that road. But I don't think that's consistent with this court's precedent, which is that if a court gives a probation revocation sentence which is legal, that's what it is, regardless of mistake of fact or mistake of law at the time of probation revocation sentencing.
And we don't send it back if we perceive the district judge made a mistake. If the pronouncement was legal, we don't send it back for a second chance to reconsider, do we?
That's correct, Your Honor. I see that I'm out of time. Unless this court has any further questions, I'm prepared to conclude my initial argument at this time.
Any more questions? You need to, just so I'm clear, your presentation has concluded.
Thank you, Your Honor.
All right, thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. So what we're looking at in this case is whether the sentence that's going forward from the probation revocation hearing, whether that was an illegal sentence. And an illegal sentence, among other things, is one that does not conform to the statutory provision either in the term or the character authorized. The defendant in this case received 24 months erroneously based on a mistaken PSI that was issued to the court in advance of sentencing. Subsequently, the defendant's probation was revoked, and the court simply stated, I'm ordering you to serve the balance of the 34-month sentence that was previously imposed. Unlike McKnight, the district court in this case did not engage in a discussion regarding post-release supervision. And I think it's improper for this court to find that just because there was an opportunity present, that error was hanging over the court, that the court necessarily availed itself of that opportunity, in that in ordering the balance of the sentence, he was necessarily, specifically intending to modify down to the 24 months post-release.
Don't we presume people know the law? And why shouldn't we presume the prosecutor and the district court knew the law? I mean, why are we giving a chance to redo?
Because there's no indication that that's what the court was doing, and that would be contrary to the precedent with respect to this issue, that McKnight, the state failed in its argument because there was a specific indication as to what the court was doing at the time of sentencing. Here, we're attempting to read into what the court was doing when there were no remarks made with respect to post-release at all.
Is the situation with the probation revocation different than with respect to sentencing in terms of pronouncements? Because we've had district judges pronounce a sentence, come back later and says, no, I really meant to do this, and we've said, no, you can't modify. Once you pronounce, it's final, it's not the journal entry.
As long as that's a legal sentence. Legal, not illegal.
And so that leads me to, could the judge here, if he determined that this is what he wanted to do, could he have imposed 24-month post-release as a sanction for probation violation?
It would be the state's position that that would be an illegal sentence. I understand that under the probation revocation statute, it says to the effect any lesser sentence could be imposed. It would be the state's position that that's any lesser authorized sentence. To speak to the contrary, to say that a defendant who is subject to lifetime post-release, under all indications of sentencing statutes for sexually violent offenders and post-release with respect to sexually violent offenders, that we're going to give him a break if he can't comply with probation. that at initial sentencing, you are mandated to receive lifetime post-release. But if you screw up on probation and you can't comply with the terms and conditions, even though you're a sexually violent offender, we're going to reward you with a lesser post-release term. That does not logically comply with the remainder of the statutory provisions that address post-release supervision and sentencing for sexually violent offenders.
And is it up to us to correct that or the legislature? Because we have said any lesser sentence means any lesser sentence. Don't we have case law that says that?
We do have case law that says that, but
And
this
so why
case,
shouldn't it be up to the legislature to say, no, that doesn't comport with the intent of the whole scheme, rather than for us to go back and change our case law and say, well, no, we're going to make a policy decision here.
I think the actual formal change would have to occur through the legislature. However, I think this court can interpret this provision in conjunction with all other statutory provisions to put it in compliance with everything else that addresses how sexually violent offenders are supposed to be managed through both sentencing and post